It's not, though.
Hello.
Oh,
I don't know what happened to our I don't know what happened to our intro.
well, I'm glad I didn't say anything embarrassing or stupid.
I know, right? Well, hello everybody. Welcome to Into the Weeds podcast on Military Broadcast Radio. I don't know if I changed the studio or what happened, but all of a sudden Tony's intro was in there. So I didn't think anybody wanted to watch basketball intro. So.
Oh, why not? No, I'm just playing.
But you guys would have been able to see Tony.
Absolutely. Joy would be really happy about that.
I know, right? Okay, well, it's good to see Joy and Teffy. I saw Millie and Stacy and Sam. And I think that's it for now. But anybody else, Toxic Barbie, anybody else watching in the background, thank you for being here.
Yeah.
We've had a pretty uneventful week. So, but a lot of things have happened too at the same time. I'm not going to talk about them. Don't want to jinx anything. But
don't want to jinx it, but we got some stuff rolling.
Yeah, we do.
It's exciting.
So, for anybody who does not know, tonight's stream is about Athena Hogan. We did a couple of episodes about her. Unfortunately, they're not very good. This is something that I am just learning how to do. So, yeah, I'm getting the hang of it. If you go back and watch them, they're pretty janky though. So.
But the point is that you're trying to get something out there. So
yes. And so I actually have quite a bit for us tonight. Let me go to my notes real quick. So this is a very personal case to me. So it's something I've actually been trying to understand since I was around 7 years old. And I didn't learn about it from the newspaper or anything like that. I was in my grandma's backyard hearing the adults talk about somebody that we knew getting arrested. That was Robert Taylor, the man who actually found Athena. And so decades later now, I have the ability to look into things, and that's what I'm doing. So we're going to look through the actual documents that built this case against Harvey Templeton. He actually went to trial and he was acquitted. And since then, there has been no movement on Athena's case. So we're going to get into what the jury saw, what the attorneys and the judge saw. And hopefully, by the end of it, we'll have maybe a clearer picture of what actually happened that day or that night. I'm really not sure. I have no idea how this is going to go.
Have you looked through it?
I have looked through it.
Okay.
I have not read all of the transcript. I'm at, I said 115, but I think it was more around 121 on the transcript. I've read all of the stuff that I'm presenting tonight. And so what we're going to do first is we're actually going to get into something called an affidavit, and it's for the search warrant and for the arrest of Harvey Templeton. And but a few Fridays ago, I went to the Comanche County Courthouse and waited there for a few hours. It was actually the day that the bomb threat happened.
Oh, wow. I didn't know about that.
Yeah, and it happened right after I left, thank God. So I think it happened around 4:30 or something like that, and I left around 3:45.
Oh, damn.
Yeah, so thank goodness.
Just a threat or?
Just a threat.
Oh.
Yeah, I don't know what actually happened, but I actually have the newspaper still in the car from the next morning.
Turns out there was a bomb threat at my work like a while ago, and it took me like over a week to even hear about it.
Yeah. So that's what I was doing. So these copies actually come from the Comanche County Courthouse. I didn't get them secondhand. I got them firsthand from them. So, and just so you know that this has not been covered in 40 years. So this happened 40 years ago this year.
Wow.
October 1st will be 40 years. So that's wild in itself. So like I said, I was 7 years old. I'm 47 now. And it's been a labor of love just to get where we are now for me, just wanting to know what actually happened. And I can't see your comments, but I'm going to look at them right now. Okay, it's good to see everybody. Thank you for being here. And we're just going to read the documents. We're not going to look at the comments. So, actually, my bad.
Bye, guys.
No, not so bad. So, I'm going to start out. And this is, like I said, this is going to be actually, oops. We're going to be reading these in full just so you guys know the expectations. This is probably going to take quite a few weeks. And this case hasn't been covered, like I said, since the trial actually happened. And there has been no movement on it, but the detective in the case, or the former detective in the case, Detective Gregory Adams, he was with the Lawton Police Department. He is now with the Fort Sill Police Department. But I know that he sent off evidence to be tested for DNA. And that was like almost 4 years ago now. I know when we were actually on our way to CrimeCon, I spoke to him when I was in the cab on our way to the convention center. I was talking to him, and he said that he was going to go back around and see what they had done in it. Haven't heard anything yet. So, what you're watching right now is the beginning of going through the record from this case, the original records, and this document I'm going to start with is part of an affidavit for a search warrant. This section is labeled Attachment C, and this is where investigators lay out what happened, what they found, and what led them to focus on a suspect. Excuse me. Okay. So it says Attachment C, page 1. That on the first day of October 1986 at approximately 9:06 p.m., the Lawton Police Department was notified of a possible dead body being found near the intersection of Northwest 82nd Street and Northwest Rogers Lane. Several police units were dispatched to the immediate vicinity of the reported sighting. Officer Robert Braley arrived at the scene shortly after being dispatched and discovered a partially clothed young Caucasian female lying on the north side of the road. The officer made an initial inspection of the body and discovered that the young female was in fact dead. He further observed that the young female was clad in a pair of white socks with red and blue stripes at the top and a pink pullover blouse. The officer observed that lodged inside of the young female's mouth was some unknown cloth article. Sometime later, identification of the young female was made, and it was determined that she was Athena Hogan, 11-year-old. Now, we know she's 10. I think she was about to be 11. So
I see it go back and forth in a lot of
documents. So see, yeah. Okay, it says she's 11 here. Who had resided at 520 Glendale in Lawton. Further investigation revealed that earlier in the day, she had left her residence to sell candy that had been obtained from her school. Further investigation revealed that the last accredited sighting of her had been around 5:30 p.m. when she was near the intersection of Northwest 7th Street and Northwest Woodridge Drive. This sighting was made by her aunt. Information also became available that at the time she had left her home, she was wearing the pink top that she was found in as well, as a pair of blue pants with multicolored zippers on the back pockets. She also was wearing the socks that have been described, as well as a pair of Care Bear tennis shoes that were described as being gray, white, and blue in color. That just breaks my heart because, I mean, the Care Bears were that was the height of when they had first come out, and
that just shows her innocence and sweetness.
Yeah. I'm gonna actually show the comments so you can look at them and all that.
Okay.
But
I agree, Marissa. It's very dangerous sending your kids, alone. And I know it was a different time. I'm glad that now people are being a little bit more. People are more responsible for what their kids do nowadays, for keeping track of their kids. And thank goodness, because it really does seem like it was a lawless wasteland back in the 80s and 90s.
No, it really was. I mean, yeah, I mean, my parents were never home in the 80s and
Yeah.
90s.
Well, your parents were also
Yeah,
your
but
parents,
but my parents were like other parents as well that
yeah.
just worked and did other things,
Yeah.
and so yeah. So, anyways, a completely different time. And I sold candy bars door to door in Lawton after this happened as well. So they didn't stop it. Now I know I've seen articles where they talked about stopping it, and they did stop it at some point, but I don't know how old I was when they stopped it. So,
Well, real quick, I just want to say I hope you're doing all right,
hey,
Kathleen.
Kathleen.
That she has she has IVs running down both
Oh,
arms.
I hope you're feeling better,
Well,
or I hope you get to feeling better,
yeah,
is
get
what I
to
wanted
feel
to say.
better.
Okay.
Prayers and love.
Yes. Okay, so the crime scene was secured by the responding officers, and notification was made to investigating officers as well as a member of the medical examiner's office. The crime scene was processed by Detective Richard Briley and Detective Cecil Davidson. Gary Jackson, a representative of the medical examiner's office, arrived at the scene and conducted his investigation. Detective Briley observed that the body indicated signs of having some sort of sticky substance on the face, as if from tape, and a bruise on the victim's left cheek area of the face. He further observed what appeared to be whip marks on the victim's buttock area. After a thorough crime scene search and processing, the body was transported to the Memorial Morgue by representatives of Becker Funeral Home. So my cousin's aunt works at Becker Funeral Home, and she's been there probably since then, and I'm going to ask her about it.
That'd be
So
good, but she's had a come throughs.
she would know.
Children
She would remember.
Stand out
She
a
would
little
remember. Yeah. So yes, I was, Marissa, afraid to sell candy bars after Athena passed away. And I remember having a moment where I went to a door and I had a really bad feeling about it. And I remember turning around and walking off. And that was the house that we were trying to find that day back behind my house.
Mm-hmm.
That was the house I was trying to figure out where that house was that I felt weird. So, okay, page 2, attachment C. The following day, October 2nd, 1986, an autopsy was performed on the body of Athena Hogan. This was conducted by Dr. R. Boatsman, who was assisted by Gary Jackson. Detective Cecil Davison was present to collect and submit evidence from the body, to include clothing and the cloth article that had been lodged in the victim's mouth. At the conclusion of the autopsy, Dr. R. Boatsman concluded that Athena Hogan had died as a result of asphyxiation due to the cloth being lodged in the victim's mouth, which had lodged against the victim's soft palate, thus obstructing the victim's air passage. Observed on the victim's body were numerous contusions, one of which was located on the victim's facial left cheek area, along with several bruises being located on the and near the buttock area that were apparently caused by some type of instrument used to whip the body with. Bruises were also on the wrists and ankles that were consistent with binding of this area. Observed on the victim's face and neck were evidence of some sort of adhesive substance, which was consistent with tape being placed over the victim's mouth. The cloth substance removed from the victim's mouth was a terry cloth-like material, light in color, with a portion torn from it. Photos were taken of the body and the autopsy by Detective Cecil Davison, and he submitted the below listed item for forensic analysis to the Oklahoma State Bureau of Investigation. 1. The terry cloth-like article taken from the victim's mouth. 2. The clothing that the victim had on her person at the time of her discovery. 1 pullover pink blouse and a pair of white socks with red and blue stripes on the upper portion of those articles. 3. A white sheet that had been used to wrap the body in and transport it to the morgue in. 4. Hair, blood, and other body cavity swabs. An investigation was begun into the death of Athena Hogan by members of the Lawton Police Department and other agencies as well. On the 16th of October, 1986, Detective Dan Belcher had the occasion to speak with Ann Reed, who is a criminalist supervisor with the Oklahoma State Bureau of Investigation in the laboratory at Oklahoma City, Oklahoma. Detective Belcher was informed by Ann Reed that she had found on the clothing articles submitted by this agency from the body of Athena Hogan in excess of 20 fibers that were consistent with carpet fibers. Ann Reed advised Detective Belcher that the fibers were of 3 different colors: red, maroon, and orange, that these fibers were very unique in their condition. Reed further advised Detective Belcher that the fibers could and was most likely from the same item and was possibly together as one unit. Attachment C, page 3. On the 12th day of October 1986, Detectives Belcher and Muhammad arrived at the residence located at 504 Northwest Woodbridge Drive in Lawton, Oklahoma, Comanche County, which is further described in Attachment A. This being the residence of Harvey and Eva Templeton and the house to be searched. Affiant with Muhammad was admitted to the residence by Harvey Templeton and once inside observed multicolored carpet, which was consistent with what criminalist Ann Reed had relayed to detectives that fiber should look like. With the permission of Harvey Templeton's officers, collected samples of the carpet from various locations throughout the residence. Affiant, along with Muhammad, held an interview with Harvey Templeton concerning the evening of which Athena Hogan had died. Affiant was informed by Templeton that on 10/1/86, that Athena Hogan had come to his residence at approximately 5:30 p.m. hours, trying to sell candy. Templeton stated that Tina Hogan had candy in a plastic bag and that she had only made entry into his residence around the front door area and did not go anywhere else in the house. Templeton stated to Affiant that Athena Hogan only stayed in his residence long enough for him to look into his wallet and to tell her that he did not want to buy any candy and that she left in an unknown direction. Templeton stated that he was alone that evening when Athena Hogan came to his residence and that his wife and his daughter were gone out of town. Templeton stated to Affiant that he could see candy through Athena Hogan's plastic bag, but did not believe she had any money inside of the bag with the candy. Affiant, along with Muhammad, had canvassed approximately 120 houses prior to coming to Mr. Templeton's and had obtained samples from several other houses and apartments in the area, and Mr. Templeton's samples was taken as part of the investigation to canvass the whole neighborhood. Now, when Ken Maines was breaking down this case, he said that they went to approximately 27 homes and gathered 27 samples of carpet. So that's quite a bit. And I believe that all of those houses were built right around the same time. So, which seems like in the 70s with the carpet. So, okay, on the 27th day of October 1986, Detective Don Belcher had delivered the samples taken from the residence of Mr. Templeton, along with several other samples from other houses, to criminal supervisor Ann Reed at the Oklahoma State Bureau of Investigation Laboratory in Oklahoma City, Oklahoma. At this time, a preliminary microscopic examination was conducted on the fibers from Mr. Templeton's residence. After examining the fibers from Mr. Temple's residence of 504 Northwest Woodridge Drive, Ann Reed stated the fibers were very consistent in color, texture, and condition with the fibers taken from the clothing of Athena Hogan. However, Ann Reed advised Detective Belcher that before a total conclusion could be arrived at, a more in-depth examination would have to be conducted. Ann Reed had told Affiant that the fibers from the clothing of Athena Hogan were there due to recent contact with those fibers prior to death, and to get the transfer of the fibers, it would have to be consistent with a long time in contact with the fiber or a violent contact with the fiber. Attachment C, page 4. On June 30th of October 1986, Detective Don Belcher had a conversation with criminalist Ann Reed. During this conversation, Ann Reed informed Detective Belcher that the fibers submitted by him on the 27th day of October 1986, taken from the residence of 504 Northwest Woodridge Drive, further described in Attachment A, matched the fibers taken from the clothing of Athena Hogan. Anne Reed told Affiant that not only did the fibers match in color and texture, but in condition as well, and that they were both one and the same fibers. Criminalist Anne Reed's qualifications for making these conclusions is based on her 13-year experience with the Oklahoma State Bureau of Investigation, a degree in chemistry, and as having been certified on past occasions in cases as an expert witness pertaining to hairs and fibers in various Oklahoma courts. Anne Reed also told Affiant that one of the red fibers taken from patched area of carpet did match a red fiber taken from victim's clothing. The red patch area of the carpet in the residence is approximately 20 feet from the front door entry of Templeton's residence of 504 Northwest Woodridge, which contradicts Harvey Templeton's statement to Affiant of victim Athena Hogan only being in the front door area of his residence. With the aforementioned information, it is requested by the affiant that a warrant be issued for the residence of Harvey Templeton, said residence being described in Attachment A of this affidavit. Okay, so I want you to read Attachment A and Attachment B.
Okay. Attachment A. The residence to be searched is located at 504 Northwest Woodridge Drive in the city of Lawton, the county of Comanche, in the state of Oklahoma. To arrive at this residence, travel to the intersection of Indian Trail Road and Northwest Mission Boulevard. Turn west and travel to the intersection of Northwest Mission Boulevard and Northwest Woodridge Drive. Turn north and travel north on Northwest Woodridge Drive. Northwest Woodridge. I don't know why I'm struggling to say Woodridge.
I was having a try.
Woodridge Drive will curve toward the west. As it curves back to the west, travel to the intersection of Northwest Woodridge Drive and Northwest 5th Place. I get a little closer. It's hard to pick up my voice unless I'm okay. Northwest Woodridge Drive will curve towards the west. As it curves back to the west, travel to the intersection of Northwest Woodridge Drive and Northwest 5th Place. To the north of this intersection, you observe Robert E. Lee Elementary School and Mission Village Baptist Church. The residence to be searched is the first residence on Northwest Woodridge Drive, traveling west from Northwest 5th Place that faces north. This residence is located from the south side of Northwest Woodridge Drive and is a single-family dwelling with an attached garage on the west side of the residence. The residence has beige brick and gray composition shingles. The trim around the residence is painted dark brown. The garage door is also painted a dark brown in color, and it has several windows. The main entry to the residence is located in the center, and it has a brown wooden door, which is covered with aluminum frame storm door. To the east and west of the entry door are two large double windows. The window immediately to the east of the entry door has an air conditioner in it. The residence has an overhanging porch that covers the entryway, west windows, and concrete porch. This overhang is an extension of the natural roof line, and the trim around it is painted tan in color. Supporting the overhang are two wooden posts that are painted dark brown in color. Leading to the main entryway is the concrete porch with two steps. On the northwest corner of the residence, by the garage, is a large evergreen tree with two mimosa trees in front of it. On the northeast corner of the residence is another large evergreen tree with an ornamental shrub next to it. Bordering the residence on the west side is the chain link fence that extends to the street. Boarding the residence on east side is a wooden fence that extends several feet north of the residence. Located on the northwest corner of a driveway is the mailbox. It is painted black in color and bears the numerals 504. Attachment B states that the property to be seized is hair, blood, fiber, and carpet consistent with evidence obtained from the clothing and body of Athena Hogan. One pair of blue pants with multicolored zippers on the rear pockets. One pair of Care Bear children's tennis shoes. And Said shoes being blue, gray, and white in color. A piece of terry cloth material consistent in shape, size, color, and tear design as the one taken from Athena Hogan's mouth during the autopsy. Tape and instruments that would be consistent with the marks on Athena Hogan's buttocks area, her face, and on her ankles and wrist. One personal item showing dominion and control of the residence. One list containing names of people victim Athena Hogan was selling or delivering Nestle Crunch candy to. Oop, touched something, my bad. So was this stuff that was found at Harvey Templeton's residence?
No, that's just stuff. Some of it's going to be seized, and then this is stuff that she had with her when she left, and stuff that they found at the scene.
Yeah, but when they say a piece of terry cloth material consistent in shape, size, and
that
color.
was in her mouth.
Well, listen to what I'm saying. A piece of terry cloth material consistent in shape, size, and color and tear design or rear. I can't even. Oh, bear design as the one taken from Athena Hogan's mouth during the autopsy.
Yeah, so they took a washcloth from his not his pantry, but his linen closet.
So, like I said, it was something.
Yeah, some of it was found at his house, and some stuff that was found at the scene.
Wow. Okay.
Yeah, so that is the arrest affidavit. So that's why they arrested him. Okay.
Is there a bear on the terry cloth? It says I can't tell what it's supposed to say. Where is it?
Says.
See, and bear design. So
the cloth in her mouth was torn.
So they're saying that the tear in that
could
versus
match
the tear. Oh, shit.
Yeah. And so that is why they arrested Harvey Templeton.
And so he was released after all that, or not released, but
he was acquitted after the trial. After the trial was said and done, he was acquitted.
Very curious as to how that happened.
Yeah, we're going to find out, because I've always been curious as to how he got acquitted. So, misbehaving. This is from Lawton, Oklahoma, my hometown, and we knew Robert Taylor. I knew Robert Taylor when I was
the original person who got arrested because he found her body.
Correct. Yeah. So that's why I'm interested in this. And then also I used to play hide and go seek and play on Robert Taylor's car as a kid, and his little brother used to drive his car to my grandma's house because he was dating my cousin. And I used to run up and down the car, go inside the car, and all that stuff. So when he got arrested, when I was standing in that circle with my aunts and my grandma talking about what happened, I thought I was going to be arrested for some reason because I was 7 and I thought he murdered her, and I don't even know, but for whatever reason, that's where my 7-year-old brain went. So
now I want to clarify. She knew the first person who got arrested because
yes,
he was brain loading. She knew the first guy because he found her. Yes. But we're not talking about the person that had this stuff in his house that might have matched up. That actually
this is Harvey Templeton, the second man who was arrested.
You knew the first man, Robert Taylor.
I knew the first man as much as a 7-year-old could know the brother of
their
cousin's boyfriend. Yeah. So whatever that means, take it as you will. But so we've got
it's a really long piece of paper.
Yeah, I know. So we've got the affidavit for the search warrant, and it just names that Harvey Lee Templeton is the person. I'm going to show you the one without the Social Security number on it.
Dead?
Yeah, but it doesn't matter. Not getting in trouble for that. So that's the affidavit for the search warrant. That's what they left there. Grounds for a search warrant. And then we have in the District Court of the 5th Judicial District in and for Comanche County, Oklahoma, the state of Oklahoma plaintiff versus Harvey Lee Templeton defendant. And it says, I, Dick W. Tannery, District Attorney, District 5 of County of Comanche and State of Oklahoma, duly authorized and empowered by law to inform offenses committed and triable within said county and state. In the name and by the authority of the state of Oklahoma, come now here and give the court to understand and be informed that at and within said county and state, on or about the first day of October 1st, 1986, Harvey Lee Templeton, then and there being, did and there willfully, unlawfully, wrongfully, and feloniously commit the crime of murder first degree in the manner of form as follows, to wit. See attachment A. And we read that to you earlier. So that's that document. I meant to digitize them when I went and got it digitized. The scanner broke and I wasn't going to wait around a bunch of hours for it to maybe come up and start working. So I'm going to hire somebody at church, I'm going to give them a few dollars and have them just, have them digitize them for me. So otherwise it'll take forever if I do it.
Shoot, I didn't know it was an option.
Hold on. Sorry. Okay. So we already read you attachment A, but I mean, if you want to read it again, just read that.
Do I?
Yeah,
I guess I will, since you handed it to me. Attachment A. That on the first day of October 1986, she said Harvey Lee Templeton did unlawfully, willfully, and feloniously, and without the authority of law, did effect the death of one Athena Marie Hogan by suffocation in the commission of the crime of kidnapping, a felony in the manner and form as follows, to wit. The said Harvey Lee... Oh, you good? The said Harvey Lee Templeton was engaged in kidnapping of the Athena Marie Hogan in Lawton, Comanche County, Oklahoma, and did then and there, while in the commission of said kidnapping, commit the crime aforesaid.
Aforesaid.
And in the alternative, that the said Harvey Lee Templeton did feloniously with malice aforethought, did then and there willfully, unlawfully, and feloniously, without the authority of law, effect the death of Athena Marie Hogan by suffocating said Athena Marie Hogan, and thereby inflicting mortal wounds to said Athena Marie Hogan, did languish and die on the first day of October 1986.
Okay. So, what's that? Now, I did try to get the FOIA from the, this is not a FOIA, by the way. I didn't fill out any Freedom of Information Act request. So this is just something I asked for, and they gave it to me. So how old was Harvey at the time of the kidnapping?
40s or 50s, right?
No, I think he was in his 30s. Yeah, I'm pretty sure he was in his 30s.
The picture that's in the thumbnail, is that him?
Yes, that's him.
That was after the crime, I'm guessing.
I'm not sure. I found it on Ancestry.com.
That man's definitely not in his 30s in that picture.
In that picture, he's probably in his 40s, I would say.
A rough 40.
But yeah. Okay. So this is, hold on, let me cough again. Okay. In the District Court of the 5th Judicial District in and for Comanche County, Oklahoma. State of Oklahoma, Comanche County, affidavit for arrest warrant on the 7th day of November, 1986, Andy A. Ferguson, being first duly sworn upon oath, deposes and says that probable cause exists and cause the arrest of Harvey Lee Templeton for the public offense against said county and state to wit, murder in the first degree, and that the probable cause of affiant believing such facts exist as follows, to wit, that I am a captain with the Lawton Police Department, and I am the investigating, okay, sorry, that I am a captain of the Lawton Police Department, and I am investigating the death of Athena Marie Hogan. There we go. That on the first day of October 1986, on the 82nd Street of Rogers Lane, in the city of Lawton, County of Comanche, State of Oklahoma, the body by Dr. R. Boatsman, that said autopsy revealed that the victim had died as a result of asphyxiation, that taken from the deceased person were certain clothing articles as well as a sheet that had been used to wrap the body in to transport to the morgue, that these clothing articles and white sheet had been sent to the OSBI lab for hairs and forensic examination, that this examination revealed certain carpet fibers and human hairs, that during the ensuing investigation of the murder of the victim, detectives of the Lawton Police Department had the occasion to make entry into a residence located at the Lawton Police Department. Oh, sorry. Sorry, this is hard to read. Okay. Let me go back. That this examination revealed certain carpet fibers and human hairs, that during the ensuing investigation of the murder of the victim, detectives of the Lawton Police Department had the occasion to make entry into the residence located at 504 Northwest Woodridge Avenue, Lawton, Comanche County, Oklahoma. This being the residence of Harvey Lee Templeton. That said detectives did obtain samples of the carpet from within this residence, that these carpet samples were submitted to the OSBI lab for forensic analysis, and that these fibers did in fact match the ones found on the clothing of the victim, Athena Marie Hogan. That detectives of the Lawton Police Department did obtain hair samples from Harvey Lee Templeton and submit same to the OSBI lab for forensic analysis, that these hair samples taken from the aforementioned person were consistent with the ones taken from the white sheet that the body of Athena Marie Hogan's body had been wrapped and transported in, that the OSBI employee that conducted these tests was criminalist supervisor Ann Reed, that investigation has revealed that on the first day of October 1986, the day of the victim's death, that one Harvey Lee Templeton did admit to having the victim in his residence. To the best of the affiant's knowledge, Harvey Lee Templeton is the last person to see the victim alive. So we've got that one. As soon as I digitize this, you can read along with us.
It'll be a lot easier to follow. I'm being honest.
Yeah,
It's
no,
really hard
no, I
to
know.
follow.
But this is cool to me. I love history, and this is huge chunk of history for my town. So, okay, in the district court in Comanche County, Oklahoma. This is a bill of particulars in rem punishment. I, the undersigned district attorney of the 5th District, Comanche County, State of Oklahoma, do upon my official oath further give the said court to know and be informed that the offense of murder in the first degree as charged within the original information was committed by the said Harvey Lee Templeton named therein and should be punished by death due to and as a result of the following aggravating circumstances, to wit, the murder was especially heinous, atrocious, and cruel, the existence of a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society. And that was signed by Dick W. Tannery, District of Attorney. So, that one. There we go. And then we have the search warrant again. But, okay. So,
Follow ones.
yeah. Thank you.
There you go. No problem.
So, that's what we've got so far. Any questions? Okay, so Miss B. Haven says, So just to make sure I understand, Athena was going door to door to sell candy, most likely for a school thing, and this Harvey grabbed her and kidnapped her. Okay. Well, we don't know that. We don't know that for sure because Harvey Templeton was acquitted.
So was Casey Anthony, though.
She was
and
too.
OJ.
Yes,
The
yes.
glove does not fit.
Yes, yes, I get this. Okay, so anyways, I have some theories. They could be totally, completely off base, but I have some theories, and eventually we'll get into them whenever it becomes relevant. But we're not going to muddy the waters already. So we've already muddied the waters too much. But yes, essentially, she was out selling chocolate bars, candy bars, the world famous chocolate candy bars, I guess is what it is.
Said Nestle.
Yeah, but I think that's made by Nestle. It was like Nestle.
Is that the ones that I sold?
Okay, well, maybe it was different back then. I remember it looking the exact same.
Did it?
Yeah, it looked exactly the same.
Those chocolate bars I used to sell were kind of gross.
Yeah. But back then, to us kids, I mean, that was big. That was before everybody took it to like. I remember when you got older and they would just take it to their church and it was crazy. It was a.
You're competing with everybody.
Yeah, you were competing with everybody. Us, we were just competing with each other as kids, going door to door, trying to, make money.
Which clearly was not the way to go.
No, I did not ever meet Athena. I never knew her. I did get in touch with her best friend, Andrea. Andrea, though, is not comfortable right now at this time in her life talking about it. I looked for the discussion that we had. I couldn't find it anywhere. I'm going to have to really scour my devices to figure out where it's at.
Or
I don't know if it was in a Facebook message or if it was in an email or if it was in a Facebook from the Lawton grapevine on Facebook, because I put stuff in there to let people know that I'm doing this. I haven't told anybody that I have this yet over there except for a few people. So, but I will plop this into that grapevine Facebook group. So
all gone through.
Well, just I'll start plopping these in there. That way they know what I'm doing. So,
gotcha.
And maybe that will get some people to come forward and talk to us. I know her aunt still lives there. My uncle, my aunt's new husband, Ed.
Why would you say that?
I'm just saying it. It's common knowledge.
Okay.
If people are in Lawton, they're gonna know. Okay, and I just want people to know. Okay, look. He was married in Athena's family somehow. He was married to her aunt or something like that. I don't remember, but she has since passed away. He is her widower. And he told me that the family was still in Lawton. And so I plan to get with Ed to actually get with the family and do it the right way. I don't want to just be stupid. You know what I mean? Since it's a family connection and everything, I feel like it's an important thing to do it that way.
You don't want to hurt anybody. A lot of times these true crime cases are really difficult because it's a really hard thing. It's someone's most traumatic life experience, and people just talk about it so flippantly on the internet, and that goes for everything.
Yeah.
So I have a lot of really conflicting feelings with a lot of aspects of true crime. Not this in particular, because this is nothing but
this is nothing but love and respect, and I want nothing but people to figure out what happened to Athena.
You're not exploiting or harassing or swinging up at people's doors.
No, because I mean, somebody actually sent me an address and I didn't feel comfortable. I was in Lawton a few weeks ago. Something just kept telling me, don't go to the residence. Wait and talk to Aunt Peggy. And, of the person that said that it was Athena's aunt. And I just didn't want to just pop up on her doorstep all of a sudden.
No, that would, no.
I didn't want to do that. So I've decided that I'm just going to go talk to my aunt and get it arranged through my uncle.
You think they'll help you?
They will help us. They will help me. And anyways, so this is the city of Lawton. This is the search warrant was okay, so this is what they found during the search warrant. Okay. Do you want to read this since I read terribly?
Read it. Okay. November 3rd, 1986. On 10/31/86, a search warrant was executed at 504 Woodridge Drive in Lawton, Comanche County, Oklahoma, with the following listed items being confiscated from the residence. 1. One exercise mat confiscated from northeast bedroom. 2. One whip rawhide type confiscated from the northeast bedroom. 3. Assorted metal rings interlocked with each other confiscated from the northeast bedroom. I wonder what that's supposed to be. 4. 48 color photographs confiscated from northeast bedroom. 5. One leather type gun case confiscated from northeast bedroom. 6. Rawhide rope confiscated from northeast bedroom. 7. One pair of child's panties confiscated from northeast bedroom.
He had a daughter.
Yeah, but I'm just reading that a whip and a pair of child's panties are found in the same room. 8. One roll of duct tape confiscated from northeast bedroom. 9. One pair of child's panties confiscated from northeast bedroom. 10. One green colored terry cloth towel confiscated from northeast bedroom. 11. One jar of Vaseline confiscated from shaving kit located in master bedroom. Oh, so the northeast bedroom isn't the master bedroom, but there was a whip in the northeast bedroom?
I don't know. It could have been something, that was.
I guess my mind's just in the gutter, but I'm just trying to wrap my
head around it. It could have been a historical thing or something.
Sure. 12. One blanket confiscated from hall closet located by back 2 bedrooms. 13. Hair confiscated from shower curtain, which was located in hall closet next to master bathroom. 14. Red cover confiscated from hallway floor between master bathroom and closet. 15. Green bathroom rug with Santa Claus picture on it confiscated from master bathroom on floor by bathtub. 16. One pair of tennis shoes confiscated from northeast bedroom closet. 17. One rag confiscated from cabinet in kitchen below sink. 18. Cord confiscated from hallway door or hallway floor next to the kitchen entrance. 19. One paddle confiscated from east wall and hallway by front hall closet. 20. Black string from hallway. 21. Hair confiscated from tan-colored boots in northeast bedroom. 22. CB antenna confiscated from living room area on floor in front of cabinet by door. 23. Green colored duct tape confiscated from right bottom drawer of stereo rack in living room along east wall. 24. One capital tote bag confiscated from living room area. Item had been located on floor next to chair. Note, items 25 through 45 listed below were located in tote bag. 25 is one ball peen hammer. 26, one hex wrench. 27, a black knife case. 28, black change carrier. 29, a claw skateboard. 30, Columbia fishing sinkers and package. 31, one roll of white toilet paper. 32, one pair of black rubber gloves. 33, 3 green colored glove inserts. I wonder what a glove insert is, to make your fingers look bigger, or
no, it's like he was a trashman, so no, but like glove inserts, it could be like the stuff that makes your hands warmer, during the winter.
Gotcha. 34, one combination lock. 35, dog chain. 36, one spoon. 37, crescent wrench. 38, pair of pliers. 39, 1.5 inch open end wrench. Let's see. This is a big tote bag.
Well,
40, one cable connector. 41, one small black leash. 42, green cord. 43, one police slapper. What's a police slapper?
I would imagine it's one of those leather things that police used back in the day to slap people with, kind of like a billy club.
That's horrible. Okay. 44,
I'm
one
assuming.
still horrible. 44, one plaid sports shirt. 45, one green slicker.
Like a rain jacket.
Ah, sorry, this is like old-timey speak. Sorry. 46, one pair of gray Hagger slacks confiscated from garage by ladder. 47, three vacuum sweepings, two taken from hallway, one from living room. 48, two long plastic bands. 49, one section of red colored carpet.
Okay. Oh. That was a lot of stuff.
Yes.
I remember when Ken Maines was breaking down the case, he said for sure if they went in there and they found porn, that he would for sure say that it was him.
If they found
He
porn,
had a much more elegant way of saying it. But
what do you mean? If they found
porn,
child?
no, just porn in general, like a big stash of porn,
Gotcha.
that in Harvey's house, that he would definitely lean more towards him having done it. He didn't have this list when he was doing his assessment either.
So what you're saying is Ken believes if there was porn in the home, that would make it more likely, in his opinion, that he would have done it.
Correct.
I don't find, well, I don't know. I don't find, especially back then when you didn't just have access to the internet. I mean, is having a porn stash really that weird when that's really the only way that they could access it?
Yeah, but he meant like an
really
excessive, like an excessive amount of porn, not just like a couple of magazines or whatever,
I mean, yeah, I get it.
So that was his assessment. Now, I believe he has his Athena Hogan video on membership only. I hope he takes it off of membership only so you guys can see his assessment, because he's awesome. He's a cold case detective. So let's see. We've got the jury list. So
those people are still alive.
I don't know. And I looked it up to see, if it was a no-go to read it, and it didn't seem like it was a bad thing.
How about we just read out the first names, and if we put or do you even need to read it out? Because you could just put it online and
okay, I'll just show you.
Or that too.
There you go. I'll put it up online with all the other documents later. Let's see. This is a court minute, and this is date 4/3/87. The undersigned judge, having issued a search warrant and having a doubt as his ability to be fair and impartial, hereby disqualifies Rayburn, I think, is the judge that disqualified himself or whatever.
Handwriting, so it's a little hard to read.
Oh, but yeah. So the first judge disqualified himself because I guess Harvey knew him in some capacity or something like that. Not really sure. Exotic Prairie, no, Ken wasn't even referring to Sam or whatever that's called now.
The exploitation of children. He was just talking about if you just had a porn stash period.
He was saying if it was an abundant amount, if it was an abnormal amount, or if it had a certain fetish or lean or bent to it.
What's a normal amount of porn stash?
I don't know. I honestly don't know. But
also, what constitutes as porn? Would some of the stuff on my wall constitute as porn technically?
Technically, because TikTok and YouTube have not monetized videos of like the video or the painting that Millennial did.
You're monetized on TikTok?
well, not monetized, but it's not whatchamacallit, seeable or pushed out into the algorithm or whatever. I don't know. I don't know what it's called.
You just mean you haven't gotten a lot of views on it? That could
No, it
just be
says on the TikTok itself, when I pull up my profile, it says not able to, I can't remember what it is, but anyway.
interesting. That's not even the worst thing on my wall. Thanks,
Yeah.
Millie. It was really cute.
Yes, very pretty. Yes, your painting, Millie. Okay. So this is another court minute, and it's Roy Calvert.
I'm sorry, I should be laughing, but misbehaving says, or if the pages are stuck together, that constitutes.
Okay. Yeah. So it says the above is hereby set for hearing before the undersigned judge that the 14th day of May, 1987, at the hour of 3:15 p.m., all parties are to appear at this time. Said hearing is in response to defendant's motion requesting the court to set a date certain for the state to complete and submit any and all physical evidence in their possession to the court for the review and examination of the defendant. Further, all parties are in agreement to said hearing. Okay, so that's just telling everybody when they're going to court. And then, let's see, we are at 56 minutes. Okay, so we've got one more thing to go through tonight. We should get through it all. This is the district court in Comanche County, state of Oklahoma, court's instructions to the jury.
Do you want me to read it?
Yes, please.
And it's just this whole stack.
Yep.
Okay. Instruction number 1. You have been selected and sworn in as the jury to try the case of the state of Oklahoma against Harvey Lee Templeton. The defendant, Harvey Lee Templeton, stands charged by complaint and information with the crime of murder in the first degree. Instruction number 2. The information in this case is the formal method of accusing the defendant of a crime. The information is not evidence, and the law is that you should not allow yourselves to be influenced against the defendant by reason of the filing of the information. The defendant has pled not guilty. A plea of not guilty puts in issue each element of the crime with which the defendant is charged. A plea of not guilty requires the state to prove each element of the crime beyond a reasonable doubt. The defendant is presumed innocent of the crime, and the presumption continues unless, after consideration of all of the evidence, you are convinced of his guilt beyond a reasonable doubt. The state has the burden of presenting all of the evidence that establish guilt beyond a reasonable doubt. The defendant must be found not guilty unless that state produces evidence which convinces you beyond a reasonable doubt of each element in the crime. Instruction number 3. Evidence is a testimony received from the witnesses under oath, agreements as to fact made by the attorneys, and the exhibits admitted into evidence during the trial. It is your responsibility as jurors to determine the facts from evidence, to follow the law stated in these instructions from the judge, and to reach a verdict of not guilty or guilty based upon the evidence, and to determine punishment if you should find the defendant guilty. It is your responsibility as jurors to determine the credibility of each witness and the weight to be given at the testimony of the witness. In order to make this determination, you may properly consider the overall reaction of the witness while testifying, his or her frankness or lack of frankness, his or her interest and bias, if any, the means and opportunity the witness had to know the facts about which he or she testifies, and the reasonableness or unreasonableness of his or her testimony in the light of all the evidence in the case. You are not required to believe the testimony of any witness simply because he or she is under oath. You may believe or disbelieve all or part of the testimony of any witness. It is your duty to determine that testimony is worthy of belief and that what testimony is not worthy of belief. It is my responsibility as a judge to ensure that the evidence is presented as according to the law and to instruct you as to the law and to rule on the objections raised by the attorneys. No statement or ruling by me is intended to indicate any option considering the facts or evidence. It is the responsibility of the attorneys to present evidence, to examine and cross-examine witnesses, and to argue the evidence. No statement or argument of the attorneys is evidence. From time to time during the trial, the attorneys may raise objections. When an objection is made, you should not speculate on the reason why it is made. When an objection is approved or sustained by me, you should not speculate on what might have occurred or what might have been said had the objection not been sustained. Throughout the trial, you should remain alert and attentive. Do not form or express an opinion on the case until it is submitted to you for your decision. Do not discuss the case among yourselves until that time. Do not discuss this case with anyone else or permit anyone else to discuss this case in your presence. Do not talk to the attorneys, the defendant, or the witnesses. If anyone should attempt to discuss this case with you, report the incident to me or to the bailiff immediately. Do not read or view or listen to any news reports of this trial. This case must be decided solely upon the evidence presented to you in this court, free from any outside influence. At this point in the trial, the attorney for the state reads the information, the plea of the defendant, and gives an opening statement. The attorney for the defendant may give an opening statement after the attorney for the state, or may elect to reserve his or her opening statement until the conclusion of the evidence by the state. Opening statements are not evidence, but serve as guides so that you may better understand and evaluate the evidence when it is presented. Following the opening statements, witnesses are called to testify. Witnesses are sworn and then examined and cross-examined by the attorneys. Exhibits may also be introduced into evidence. After the evidence is completed, I will instruct you on the law applicable to the case. The attorneys are then permitted closing arguments. Closing arguments are not evidence and are presented for purposes of persuasion only. When closing arguments are completed, the case will be submitted to you. You will then retire to consider your verdict. The attorney for the state may proceed. Instruction number 4. Since all the evidence in this case has been given to you, it is now my duty under law to give you the instructions that apply in this trial. The instructions contain all rules of the law that are to be applied by you in this case, and all of the rules of law which you are to weigh the evidence and determine the facts in an issue deciding this case and in reaching a verdict. You must consider the instructions as a whole and not as a part to the exclusion of the rest. All the testimony and evidence which is proper for you to consider has been introduced in this case. You should not consider any matter of a fact or of law except what has been given to you while this court is or has been in session. Instruction number 5. The defendant, Harvey Templeton, is charged in the complaint and information with murder in the first degree as follows. The defendant did unlawfully cause the death of Athena Marie Hogan by suffocating her, either while in the commission of the crime of kidnapping, a felony, or with malice and forethought, or on or about the first day of October 1986 in Comanche County, Oklahoma. To this charge, the defendant has entered a plea of not guilty. Instruction number 6. The defendant is presumed innocent of the crime charged, and the presumption continues unless, after all consideration of all the evidence, you are convinced of his guilt beyond a reasonable doubt. The state has the burden of presenting the evidence that establishes guilt beyond a reasonable doubt. The defendant must be found not guilty unless the state produces evidence which convinces you beyond a reasonable doubt of each element of the crime. Instruction number 7. No person may be convicted of murder in the first degree unless his conduct caused the death of the person allegedly killed. A death is caused by the conduct if the conduct is a substantial factor in bringing about the death and the conduct is dangerous and threatens or destroys life. Instruction number 8. No person may be convicted of murder in the first degree unless the state has proved beyond a reasonable doubt each element of the crime. The elements of murder in the first degree while in the commission of the felony kidnapping are: first, the death of a human. Second, the death occurred as a result of an act or an event which happened in the commission of a kidnapping. Third, caused by the defendant while in the commission of kidnapping. Fourth, the elements of the kidnapping the defendant is alleged to have been in the commission of are as follows. First, unlawful. Second, forcible seizure and confinement. Third, of another. Fourth, with intent to confine secretly. Fifth, against the person's will. Instruction number 9. A person is in the commission of a kidnapping when he is performing an act which is an inseparable part of a kidnapping, or which is necessary to complete the course of conduct constituting a kidnapping, or when he is fleeing from the immediate scene of a kidnapping. Instruction 10. No person may be convicted of a murder in the first degree unless the state has proved beyond a reasonable doubt each element of the crime. The elements of murder in the first degree with malice and forethought are: first, the death of a human; second, the death was unlawful; third, the death was caused by the defendant; fourth, the death was caused with malice and forethought. Instruction number 11. Malice aforethought means a deliberate intention to take away the life of a human being. As used in these instructions, malice aforethought does not mean hatred, spite, or ill will. The deliberate intent to take human life must be formed before the act and must exist at the time a homicidal act is committed. No particular length of time is required for formation of this deliberate intent. The intent may have been formed instantly before commission of the act. Instruction number 12. The external circumstances surrounding the commission of a homicidal act may be considered in finding whether or not deliberate intent existed in the mind of the defendant to take a human life. External circumstances include words, conduct, demeanor, motive, and all other circumstances connected with a homicidal act. Instruction number 13. Homicide definitions: direct result, immediate consequence, which is not separated from its initial cause by other independent factors, and the commission of performing any act which is an inseparable part of a crime or necessary for its completion, or fleeing from the immediate scene of the offense. Instruction 14. You should consider only the evidence introduced while the court is in session. You are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified when considered with the aid of the knowledge in which you possess in common with other persons. You may make deductions and reach conclusions which reason and common sense lead you to draw from the facts which you find have been established by the testimony and evidence in the case. Direct evidence is a testimony of a person who asserts actual personal knowledge of a fact, such as the testimony of all eyewitnesses. Direct evidence may also be an exhibit, such as a photograph which demonstrates the existence of a fact. Circumstantial evidence is the proof of the facts or circumstances which gives rise to a reasonable inference of other connected facts that tend to show the guilt or innocence of a defendant. It is proof of a chain of facts and circumstances that indicates either guilt or innocence. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. Circumstantial evidence should be considered by you together with all the other evidence in the case and arriving at your verdict. Instruction number 15. A defendant who wishes to testify is a competent witness. The defendant's testimony is to be judged in the same way that any other witnesses is. Instruction number 16. Evidence has been presented that the defendant has committed conduct that may affect his credibility. This evidence is called impeachment evidence, and it is offered to show the defendant's testimony is not believable or truthful. If you find that this conduct occurred, you may consider this impeachment evidence in determining what weight and credit to give the credibility of the defendant. You may not consider this impeachment evidence as proof of innocence or guilt. You may consider this impeachment evidence only to the extent that you determine it affects the believability of the defendant, if at all.
I find it interesting that we're seeing these jury instructions from 1986. To me, as a history nerd, this geeks me out, actually.
It seems pretty consistent with normal jury instructions. I just think it's because a lot of people in the jury don't understand entirely what it entails. You know, since we pay attention to true crime, we know what you're expected of as a jury. But this is just to put it on paper so everyone knows. But I mean, it's pretty standard, I would say.
I've never actually been on a jury as an adult. I have been on several juries in teen court, and I was the prosecutor in teen court for like two years, I think. I participated in teen court. I absolutely loved it. And I actually participated in that at the Comanche County Courthouse. So when I went there to get those documents, it felt like home. It really did, because every Wednesday night, I believe it was, I would go there and hang out with my friends that all participated, and we would give people community service, make them pay fines. And it was fascinating, and it was so funny. One time, so I I was the prosecutor against this one kid who stole beer from a convenience store. And about 2 weeks later, I go to my friend's house and I walk in and her brother's sitting there and he stands up and he's like, "Oh, hell no."
Well, you were the rat. Why are you the prosecutor? You should be the defense attorney. Come
And
on,
I had
man.
been hanging out with his sister for a while. I just didn't, I had never met her brother. And then, you know, we all got to know each other and it was fun. But, but yeah. So, anyways, I just figured I'd break it up a little bit.
No, absolutely.
Yeah, awkward.
I wouldn't be afraid of being on a jury. I would definitely I could objectively look at something. I think for the most part, except for in very specific circumstances, I can probably put my personal feelings aside to abide by the law and what I find true. But there are some cases that I could find a little more difficult. I would not want to be on the jury of something that has to do with any kind of child harm.
Actually, when I first was trying to get all of this information or any information, I wanted to pass it off to Stephanie Harlow because I thought that they would get like autopsy photos or more graphic descriptions and stuff like that. I'm sure that is somewhere. No, this just in Athena's case, I was like really afraid of seeing that because I didn't want to know that or see that kind of stuff.
I get it.
When I first started thinking about this case and pushing it out, I did send it to a bunch of people, you know, to try and get them to cover it, but no one could find anything on it. So, yeah, and even Millennial today was like, "Hey, I can't find anything on it."
Exotic Prairie said, I think Casey Anthony is because it was death penalty case. They have taken that off the table. I think she would have been found guilty. That's exactly what the jurors who have come out and spoken about it said.
And this looks like it was a death penalty case as well. So
yeah, but especially since she was so young, I think she was like maybe 21, 22 whenever they were maybe 23 when she was being tried. And that's really, really difficult. That's fair. But yeah, the Casey Anthony thing is something that particularly pisses me off because I used to be very, very, very close with somebody who was in the trial. So, very much pisses me off.
Yeah, so they did run DNA tests. I think it was sent to OSBI. Some evidence was sent to OSBI. Like almost 4 years ago now when the detective called me because I had put in a Freedom of Information Act request on Athena, and he called me and he's like, "Hey, why are you looking into this case?" And
it does seem a little sus. Not that it is, but I can imagine.
And so I was like, well, so I just told him what I've told you guys, that I knew the guy who found her. I thought those footprints on his car were mine. And then he said, well, that's really weird because you're the first person to look into this case in over 30 years. I just got assigned this case a few months ago, and I just sent DNA testing off like last month. And it freaked him out that all of a sudden I'm looking into it as soon as he gets assigned to the case.
I'm sure.
And as soon as he sends the DNA off or the evidence off. So yeah.
That would freak me out for sure, especially since it's such an unknown case. I mean, like, obviously some of the locals know about it, but it hasn't been talked about in 30 years.
Well, and nobody looked into it. Legit, nobody looked into it. Like, not even, I guess, the news or anything. I don't know. I mean, I would imagine that.
I hate to say it, but so many people pass away every day. So many people's lives are taken. I mean, somebody got murdered like right next to my job a few months ago. Someone got murdered at a bar I used to frequent. I mean, there's things happening all the time, or even just around here, and we don't even hear about half of
Yeah,
it.
that's the
You know
point
what I
is we
mean?
don't hear about
So
it. Yeah.
I can understand why.
Mhm.
Understand why. It's unfortunate,
Yeah.
but I can understand why.
Okay. So
You want me to
let's
finish this and then we
yeah,
can
let's
wrap
finish
it up?
this. Yeah.
Wrap her up. We're on 17 out of, I think, like 21.
Yeah.
And they're all short. Well, most of them are short.
Yeah.
Anyway, instruction number 17. Ladies and gentlemen, you're further instructed that during the course of this trial, collateral issues have come into evidence. Collateral issues are issues that are not directly connected with the innocence or guilt of the defendant. You're instructed that the proof or disproof of any such collateral issue may not be used in consideration in the defendant's guilt or innocence. You may consider collateral issue evidence only to the extent that you determine it affects the believability of the witnesses at all.
Sorry.
Instruction number 18. You're further instructed that the statutes of the state provide that a person who is convicted of murder in the first degree shall be punished by death or by imprisonment for life. At this stage of the trial, you shall limit your deliberation to whether you find the defendant guilty or not guilty. The question of punishment, if any, for murder in the first degree is not before you at this time. If you find the defendant guilty of murder in the first degree, there will be a subsequent sentencing proceeding for you, the jury, to determine whether the defendant should be sentenced to death or life imprisonment. Instruction number 19. Should you find from the evidence under the instructions herein given you and beyond a reasonable doubt that the defendant is guilty of murder in the first degree while on the commission of the felony kidnapping or murder first degree with malice aforethought or in forethought is charged or as charged in the complaint and information and as defined in these instructions, then you should find the defendant guilty as charged. But if you do not so find, or should you entertain a reasonable doubt thereof, then in either of said latter events you shall find the defendant not guilty. Oops. Instruction number 20. Testimony has been introduced of certain witnesses who purport to be skilled in their line of endeavor. Such witnesses are known as expert witnesses. An expert witness is one who's skilled in any certain art, business, or profession, or who is possessed of peculiar knowledge acquired by study, observation, and practice. You may consider the testimony of these witnesses and give it such weight and value as you think it should have, but the weight and value to be given to their testimony is for you to determine. You are not required to surrender your own judgment to that of any person testifying as an expert, or to give controlling effect to the opinion of an expert, for the testimony of an expert, like that of any other witness, is to be received by and given such weight and value as you deem it is entitled to receive. Instruction number 21. The court has made rulings in the conduct of the trial and the admission of evidence. In so doing, I have not expressed nor intimidated intimated.
Oh, intimated.
Sorry. Intimated in any way the weight or credit to be given any evidence or testimony admitted during the trial, nor have I indicated in any way the conclusions to be reached by you in this case. It is your responsibility to determine the credibility of each witness and the weight to be given the testimony of each witness. In determining such weight or credibility, you may properly consider the interest, if any, which the witness may have in the result of the trial, the relation of the witness to the parties, the bias or prejudice of the witness, if any has been apparent, the candor, fairness, intelligence, and demeanor of the witness, the ability of the witness to remember and relate past occurrences, the means of observation, and the opportunity of knowing the matters about which the witness has testified. From all the facts and circumstances appearing in evidence and coming to your observation during the trial, aided by the knowledge which you each possess in common with other persons, you will reach your conclusions. You should not let sympathy, sentiment, or prejudice enter into your deliberations, but should discharge your duties as jurors impartially, conscientiously, and faithfully under your oaths, and return to such a verdict as the evidence warrants when measured by these instructions. After you have retired to consider your verdict, select one of your number as foreman and enter upon your deliberations. When you have agreed on a verdict, your foreman alone will sign it, and you will, as a body, return it in open court. Your verdict must be unanimous. Forms of verdict will be furnished. You will now listen to the argument of counsel, which is a proper part of this trial. And it's signed by Judge Jack Brock.
I think so. Yeah. Brock.
The date, July 21st, 1987. And that is that. Folks.
That is that for today. So I made sure and I got everything officiated. Can you hand that to me? I got the seals on them and everything. That way, you know, whatever happens, and people know that they're real. So we've got
Absolutely.
that. And then I'm going to show you. We've got, I read those, didn't I?
Yeah, you read everything.
I read that.
Over there.
Okay, so
Yes,
that's
ma'am.
all we have for tonight.
Thank you all for joining. This is something that's clearly very near and dear to my mom's heart, and it's something I've grown to care about as well.
This box has a bunch of motions and
a big boy box.
Hold on.
It's heavy. Don't hurt yourself.
No, I'm not.
Just making sure you don't tangle yourself up, Mom.
Okay. Yeah. So it's got subpoenas, motions.
Oh, and that's where that rubber band I was playing with came from.
Motions for release of evidence. And then I've got the transcript testimony of Robert Taylor, the transcript testimony of Harvey Templeton, and then just the entire testimony or the whole transcript. So they broke it down. That's how they had it in the files. So that's how they gave it to me. So we've got a lot to go through. A lot of the motions we'll read, but I don't think we'll read all of the subpoenas and stuff. I'll just give you a brief overview of what they are. And
important, but
they're
you'll
important.
Be falling asleep if we're just reading every single bit of it.
Yeah. And I want to get to the meat and potatoes, the actual trial transcript. So I'm excited about this. I only want this to be solved, and please pray that happens.
Between this and the Lawton serial killer case, it would be really great to be able to make some progress on this.
Yeah, and just get some justice for these victims. Athena is just something I've thought about since I was 7 years old. And when you're thrust into that kind of stuff at an early age, you know, I guess that's what creates me. That's what creates me. So, yeah. So that is what we're doing. And I encourage you to please just come back and keep following us and learning with us about Athena Hogan. And hopefully I can get to Lawton soon and, you know, talk to some people. If you knew Athena, or if you know anything about Robert Taylor or Harvey Templeton, and you feel comfortable actually speaking to me, please reach out to me. My email address is intotheweeds@mbradio.us. And, or you can go on the military broadcast website, and it's mbradio.us, and leave a message or call us or whatever. And I'll talk to you. We can either have a face-to-face on something like this, where you come into my office and you just talk to me without an audience, or you can email me, or we can talk on the phone. But it's something that's important to me, and I'm hoping that we can roll this into something, you know, important to get the case solved or spur somebody to care. I don't know. That's all I care about, honestly. I just want to know once and for all, did Harvey Templeton do it? Did they acquit the murderer, or is he been out there this whole time? So, that's my question.
I mean, they stopped looking for the killer once Casey Anthony's thing kind of, went through. Doesn't seem like there's been a lot of developments. It's very possible they might have let the man go. It's also possible something else happened. But
I would like to talk to some of the old detectives. I left a business card at the sheriff's office desk. The receptionist was really nice. And but he was out of town, or the coordinator or something was out of town. And so yeah, that's what we've got right now. I may or may not be here next week. I'm not sure. Alora may have to read some stuff out. Maybe, depending.
I say if you're not here, I'm probably going to do something else.
Yeah.
Just because this is your case and I'm not going to do it justice.
Okay.
I care about it, but
you can do something on the Duggars.
There's a lot happening on the Duggars right now.
So it's my 26th wedding anniversary on the 15th. And my husband and I are thinking about going and seeing some redwoods and stuff like that. So
that'd be cool.
We're excited to do that. And last year we went to Eureka Springs. I think I'm Eureka Springs out for a while. We've been there so many times.
At least for something like big like this.
Yeah. And we had our honeymoon there in Eureka Springs.
I've never been here. Never been.
So anyways, so we're going to go see if we can see some big old trees and stuff like that. And I hope everybody has a really great Easter. I'm excited. I'm going to have a roast and a Brussels sprouts and potatoes, all the stuff I'm not supposed to eat.
Yeah, no kidding. Is that your email?
Brussels sprouts.
Is that correct? Into the weeds at
nbradio.us. Yep.
Okay, I'm putting it in the chat because Exotic Prairie asked.
Yes.
And it's easier to just look at it.
Thank you very much.
Into the Weeds podcast, or Into the Weeds, no podcast.
Into the Weeds at nbradio.us. Yes. So that's what I'm going to be doing. And I'm not sure if I'm going to be here this week or next week. I'm not sure what's happening. So we'll see. Molyneux asked who was about to get...
Who's getting roasted?
Who's getting roasted?
Me, probably.
Yeah.
I'm easy to bully. But I'm also a bully, so.
I'm easy to bully too. I'm very easy.
If someone bullies my mom, they're getting their ass beat. Only I can bully my mom.
No. Okay, so anyways, I hope that everybody has a very blessed night and that you go out and do something good to change the world for the better. Bye, everybody.
What she said.
Ladies and gentlemen, thank you for tuning in to Military Broadcast Radio. As we wrap up today's show, we want to remind you that the podcast of today's episode will be available right after we go off the air. So if you missed any part of the show or want to listen again, be sure to check it out. And remember, we're here to support and honor our veterans. Your stories and experiences matter, and we are committed to giving you a platform to share them. That's right. We're here to give our veterans a voice. So don't forget to catch the podcast and stay connected with us. Giving our veterans a voice.